My ex-husband's fiancée removed my daughter from the flower girl role just 30 minutes before the wedding, but what my former mother-in-law did next left the entire ceremony speechless. They don't want me anymore. That's what my 8-year-old whispered into my ex-husband's phone 30 minutes before his wedding. I was doing 60 in a 30 zone when I heard it, and I don't remember a single red light between my kitchen and that chapel parking lot. That morning, I'd curled Lily's hair in soft ringlets. I'd sewn 41 freshwater pearls onto the bodice of her flower girl dress by hand, one at a time, because the seamstress wanted $300 extra to do it by machine, and I wanted my daughter to feel like someone had loved every inch of that dress into existence. My fingers ached for 2 days afterward. I told her she'd look like a princess. She spun in front of my bathroom mirror in her socks and asked, dead serious, if princesses got nervous too. I told her they did, that even brave people feel their stomachs flip before big days. I did not tell her that in 90 minutes, a 26-year-old woman with a spray tan and a $5,000 dress would look at her like she was a stain on a tablecloth. My name is Dana Whitfield. I'm 36 years old. I work as a compliance analyst for a regional credit union, and until that Saturday in September, I thought the worst thing my ex-husband's family had ever done to me was forget my birthday 4 years running. I was wrong about a great many things that day. But I want to start at the beginning, because the ending doesn't mean anything if you don't understand what it costs to get there. And because by the time this story is over, you'll understand exactly why Mark's mother didn't sit down when she walked into that chapel. She'd spent 30 years building something quietly, patiently, the way people do when they've learned not to trust the ones who are loudest in the room. And on that Saturday, she finally decided to spend it. Mark and I were married for 9 years. We have one daughter together, Lily, who was 3 when we separated and is 8 now. Sharp, funny, prone to narrating her stuffed animals' internal lives in voices that don't match their species, and, since the divorce, quietly, carefully attentive to the moods of every adult in a room. Kids do that. They learn to read weather patterns in grown-up faces long before they should have to. Mark left 5 years ago. He didn't frame it that way at the time. At the time it was, we've grown apart, delivered with the practiced sincerity of a man who has rehearsed a sentence in his car. What he'd actually grown apart from was fidelity. Her name was Brittany. She was 26 to his 39, worked in medical device sales, and had a laugh that carried across restaurants. I found out about her 3 weeks before Mark moved out, when I saw a hotel charge on a shared credit card statement for a Tuesday night in a city Mark claimed to have never visited. I'm not going to pretend the divorce was some dignified, made-for-television split where everyone cried gracefully and co-parented in matching cardigans by the second act. It was ugly for about a year. Then it settled into something colder and more survivable, the kind of arrangement where two people who used to build a life together now communicate primarily through a co-parenting app, in sentences edited for tone before sending. But Lily loved her father. Loves him still, as far as I can tell, in the uncomplicated way small children love the people who show up even part of the time. So when Mark called in July and said Brittany wanted Lily to be their flower girl, I said yes before I'd even fully processed the request. Not for Mark, not even really for the wedding. For Lily, who lit up like a struck match at the idea of walking down an aisle in a dress with her name on the invitation. I should have asked more questions. I've replayed that call 100 times since, listening for a tone I might have missed, a hesitation that would have told me Brittany's enthusiasm for my daughter's presence was thinner than advertised. I didn't hear one. Mark sounded normal, which, in retrospect, might have been the first red flag, because Mark sounding normal about anything involving Brittany usually meant he'd already surrendered the argument before it started. There was a moment in August that I dismissed too easily. Lily came home from a weekend at Mark's and mentioned, almost as an aside while she was building something elaborate out of Legos, that Brittany had asked her not to call me mommy in front of Brittany's family at an engagement dinner. Just, could she maybe say my mom instead of mommy because it sounded more grown up? I asked Lily how that made her feel. She shrugged. The specific 8-year-old shrug that means I don't want to talk about this, but I also don't fully understand why it bothered me. I let it go. I told myself it was a small thing, a silly preference, the kind of minor territorial nonsense that new partners sometimes indulge in and grow out of. I did not yet understand that with Brittany, small things were never actually small. They were test balloons. The morning of the wedding, Lily was radiant. I curled her hair with a 1-inch barrel iron because I'd read that smaller curls hold longer through a ceremony, and I sewed those pearls on while she watched television, humming along to a jingle from a commercial. She kept coming to check herself in the mirror, twirling, asking if the dress made noise when she moved. She wanted it to make noise, she said, like the dress in a movie she loved. I drove her to the venue myself since I wasn't invited to the ceremony, and Mark's family had arranged for her to get ready with the bridal party. I remember the drive. I remember dropping her at a side entrance where a wedding coordinator with a clipboard and an earpiece took her hand and told her she looked beautiful. I remember driving away and feeling, for a strange half-second, proud of the dress, of the pearls, of the fact that despite everything, Lily still got to have this small, sparkling day. I got home. I made coffee. I sat down to answer emails from work, because compliance audits do not pause for other people's weddings. 40 minutes later, my phone rang. It was Mark's number, but it wasn't Mark's voice. They don't want me anymore. Lily's voice on the phone was small and wet, the specific broken register of a child trying very hard not to fully cry, because some instinct tells her that crying too much will will make things worse. I asked her what happened. She couldn't get through more than fragments, Brittany said. Daddy didn't. I want to go home. Before the coordinator's voice cut in, apologetic and rushed, saying there'd been a change to the ceremony lineup, and could I come get my daughter? I don't remember the drive. The brain triages what it keeps during acute stress, apparently, and mine decided traffic patterns weren't worth the storage space. I remember arriving. I remember a valet trying to direct me to guest parking, and me telling him I wasn't a guest. I was a mother, and driving past him to the first open space I saw. A coordinator, different from the one who'd taken Lily earlier, met me just inside and steered me toward a side room off the main hall, speaking in the low, careful tone of someone trained to de-escalate wedding day crises that are generally about missing boutonnieres, not about a child's dignity. Lily was sitting on the floor of that side room, dress crumpled around her, the little woven basket of rose petals dumped and scattered beside her like she'd thrown it, or like someone had taken it from her hands. Her hair, which I'd curled so carefully 3 hours earlier, had come half loose on one side where she'd clearly been pressing her face into her knees. Brittany was standing at a full-length mirror across the room, adjusting an earring, not looking at either of us. What happened? I asked her. My voice came out flatter than I expected. I think some part of me was still operating in compliance analyst mode. Gather facts first, react second. Brittany glanced at me in the mirror's reflection rather than turning around. A new family shouldn't start with reminders of the old one, she said, like she was reciting a line she'd practiced in front of that same mirror. Then she actually turned, looked at Lily, really looked, the way you'd look at something spilled on good carpet, and added, besides, she looks too much like her mother. She said it, and then turned right back to her reflection to check her lipstick, as if she hadn't just said something to gut a child in a dress with 41 hand-sewn pearls on it. Brittany did not raise her voice. She did not seem angry or even particularly invested. She said something devastating with the mild irritation of someone commenting on weather that was inconveniencing her outdoor plans. That flatness is, I think, what I remember most clearly. Cruelty delivered as a scheduling note. I turned to Mark. He was standing in the doorway, which meant he'd been there for at least some of this, possibly all of it. His face had the particular stillness of a man doing complicated math about which is worse, this moment or the moment where he says something and Brittany turns that same flatness on him. Say something, I told him. He looked at his shoes, genuinely looked down, like the leather might contain instructions. Brittany's stressed, he said. Big day. That was it. That was the sum total of 5 years of co-parenting, 9 years of marriage before that, a lifetime of being this child's father, reduced to a shrug about someone else's stress levels, while his daughter sat on a floor in a dress that no longer had anywhere to go. I did not scream, though I think people expect the mother in this story to have. I knelt down. I gathered Lily into my arms. I told her the dress was still the most beautiful dress I'd ever seen and that we were leaving, and I meant to just walk her straight out to my car and let the whole wedding become someone else's problem. That's when I saw Carol standing in the hallway. Carol Whitfield is Mark's mother, 68 years old at the time, widowed for 6 years. The kind of woman who says please to waitstaff and means it, and who I had, across 11 years of knowing her, watched absorb an enormous amount of family dysfunction with the placid patience of someone who'd decided long ago that most battles weren't worth the blood pressure spike. She was standing very still in the hallway outside that side room, still enough that I understood immediately that she'd heard everything. Brittany's comment about the old family, the line about Lily looking too much like her mother, Mark's shoes-focused apology for someone else's stress. I watched her eyes move, from Brittany to Mark to the basket of scattered petals to Lily's crumpled dress. Something closed in her face while I watched, not dramatically, not with any performance in it. It was quiet and final, the specific look of a door being locked from the inside by someone who has finally, after a long time, stopped negotiating with whoever's on the other side of it. She didn't say a word to any of us. She turned and walked away down the hall, back toward the main chapel. I assumed in the moment that she was embarrassed, that she'd disappear into her seat in the second row and spend the ceremony pretending this hadn't happened, the way I'd watched this family absorb every uncomfortable moment for over a decade. Mark's family has a particular talent for institutional silence. Nobody raises their voice. Everybody simply agrees later, never to discuss it. I was wrong. I gathered Lily, told her we were going home to change into pajamas and order whatever food she wanted, and started walking her toward the exit. We didn't make it out of the building. I heard the chapel doors, the big double doors at the front of the sanctuary, open with the specific heavy sound that carries through an entire building when 200 people go simultaneously silent to see who's coming in late. Lily and I were near a side exit that ran parallel to the main aisle, separated from the sanctuary by a half wall and a row of ushers' chairs, and out of some morbid instinct I stopped walking and looked through the gap. Carol was walking down the center aisle of the chapel, carrying something long and rectangular, wrapped carefully in white satin fabric, the kind of careful, ceremonial wrapping that made it look absurdly like she was carrying a rifle to a duel rather than a gift to a wedding. She did not sit in her seat. She walked the entire length of that aisle, past 200 guests in their good clothes, straight up to the altar, where Brittany was standing in her $5,000 dress, glowing with the specific luminosity of a woman who believes the day belongs entirely to her. "Sorry I'm late," Carol said, and her voice carried. She'd worked as a courtroom stenographer for over 20 years before retiring, and she knew exactly how to pitch switch a sentence so the back row heard it as clearly as the front. Had to get your wedding gift. Brittany's whole face brightened. I watched it happen from behind that half wall. She loves gifts. She loves them. I'd learn later from more than one source, almost as much as she loves being watched receiving them. She tore the satin wrapping off herself right there at the altar, guests craning forward. Inside was a gold frame. A photograph of Mark as a small boy, no older than 5 or 6, held in the arms of his late father, Carol's husband, who I'd known for 4 years before he passed. A quiet, careful man named Walter, who ran a small commercial real estate business, and who had, I would learn in the coming weeks, been considerably less quiet about his intentions on paper than he ever was at a dinner table. Beneath the photograph, mounted in the frame, a brass plaque, freshly engraved. A family is built on the children you love, not the ones you erase. Nobody breathed. I mean that almost literally. Somewhere near the back of the chapel, a fork clinked against a plate during the cocktail hour setup, and then went completely silent, like even the caterers understood something had shifted in the room. Brittany stared down at the frame in her hands like she was waiting for the words to rearrange themselves into something less true. Carol turned away from her and faced the guests. 200 people in their Sunday best, some of them still holding drinks from the reception space, all of them now leaning very slightly forward in their seats. I had this made as a blessing, Carol said. But 30 minutes ago, this woman told my 8-year-old granddaughter that she looks too much like her mother. Told her she doesn't belong in this family. A woman in the third row, I'd learn later this was Brittany's own aunt, audibly gasped. Brittany's smile cracked visibly at the edges, the first real fracture I'd see in a performance that would go on cracking, piece by piece, for the next several weeks. Carol, that's not— my husband left me everything, Carol said, and she did not raise her voice to cut Brittany off. She simply continued at the same measured volume, the way you'd talk over a child interrupting a story, confident the story would win. Every account, every property, including the trust that is currently paying for this venue, this dress, and the honeymoon you have not, I believe, stopped posting about since April. She let that sit in the room for a long moment. Then she turned and looked directly at her son. Not $1 of it touches this marriage, she said, while my granddaughter is treated like something to hide. I watched Mark's face go the color of the tablecloths. Brittany turned toward him, and even from behind that half wall, 30 feet away, I could hear the specific, thin panic climbing into her voice. Mark, she said. What is she talking about? And Mark, who had spent the last 5 years perfecting the art of saying nothing at the exact moment something needed to be said nothing at all. I picked Lily up, even though she was really too big at 8 to be carried comfortably, and I walked her out to the car, because whatever was about to happen in that chapel was not something an 8-year-old needed to watch unfold in real time, no matter how much she'd earned the right to see it. I want to pause the timeline here, because everything I've described so far, I witnessed directly. Everything from this point forward, I reconstructed over the following 6 weeks, through documents, through 3 professionals I'll introduce properly, and through Carol herself, who I came to understand far better in that stretch of time than I had in the previous 11 years combined. Here's what I didn't know. Standing in that hallway with a shell-shocked 8-year-old on my hip, Carol's husband Walter had not died suddenly. He'd been diagnosed with pancreatic cancer 14 months before his death, and in that window, while everyone else in the family was managing their grief in the ordinary, chaotic ways people do, Walter had quietly, methodically restructured almost his entire estate. He hadn't done this because he distrusted Mark, specifically. He'd done it, according to the attorney who eventually walked me through the documents, because Walter had watched his own brother lose a modest inheritance to a second wife's family within 18 months of a hasty remarriage, and he'd told Carol in the last year of his life that he didn't want their money to become a hostage in somebody else's marriage. So Walter had done something that a lot of estate attorneys will tell you is more common than people assume, and considerably smarter than people give it credit for. He'd placed the bulk of the family's assets, the commercial properties, the investment accounts, a life insurance payout north of $2 million, into an irrevocable trust naming Carol as trustee and primary beneficiary for her lifetime, with Mark and any grandchildren as remainder beneficiaries, subject to a set of conditions Walter had drafted with unusual specificity for what most people assume is a simple estate planning document. One of those conditions, buried in language that Carol herself told me she hadn't fully absorbed the weight of until the week of the wedding, gave the trustee, Carol, discretionary authority to withhold distributions to any beneficiary's household if the trustee determined, in her sole judgment, that a beneficiary's marital household posed a documented risk of emotional or financial harm to a minor beneficiary or dependent of a beneficiary. Walter, it turned out, had been thinking about grandchildren he'd never even met yet when he wrote that clause. He'd been thinking, generally, about exactly the kind of situation that unfolded in that side room with the scattered rose petals. Carol had known this provision existed. She told me later that she'd hoped, genuinely, never to have to use it, that invoking it felt, to her, like a kind of failure, an admission that the family Walter had spent 40 years building had produced someone capable of doing what Brittany did in that room. But she'd also, I came to learn, spent the better part of a year quietly watching Brittany with the specific, patient attention of someone who suspected a storm was coming and wanted a full record before it arrived. 3 days after the wedding, Carol called and asked if I'd meet her at her attorney's office. I almost said no. I was still furious, still processing, still watching Lily for signs of lasting damage from an afternoon that no 8-year-old should have to survive, but Something in Carol's voice told me this wasn't a social visit. The attorney's name was Renata Alvarez, a trust and estates specialist with the firm Alvarez & Kwan, who'd spent, by her own account, 22 years handling exactly this category of family conflict. Wealthy patriarchs and matriarchs trying to protect grandchildren from step-parents and second spouses who saw a remarriage as a shortcut to generational money. Renata laid it out plainly. Walter's trust was airtight. She'd reviewed it herself when it was drafted, and again in the days after the wedding, hunting for any weakness Mark's attorney might exploit. The discretionary withholding clause was, in her opinion, about as bulletproof as language gets in this area of law, because it didn't require Carol to prove abuse in any criminal or civil sense. It only required her, as trustee, to document a good faith, reasonable basis for believing a risk existed, and to apply that standard consistently rather than punitively. The word she used matters, Renata told me, tapping a printed transcript of Brittany's comment that Carol had remarkably written down verbatim within minutes of hearing it, right there in the hallway on the back of a ceremony program. She looks too much like her mother isn't just cruel. It's a stated intention to marginalize a specific child because of that child's connection to a specific person. That's not a bad mood. That's a documented position. I asked Renata what would happen next. Carol, as trustee, was well within her rights to formally suspend all discretionary distributions to Mark's household, meaning the monthly support that had, I learned in that meeting, been quietly covering roughly 40% of Mark and Brittany's combined household expenses since before the wedding, structured through the trust as an advance on inheritance arrangement Mark had never disclosed to me during our marriage or after it, because it had started only in the last 2 years of Walter's life. 40%. I sat in that office chair and did the math on 5 years of quiet resentment I'd carried about Mark's supposedly modest paralegal salary, somehow stretching to cover a downtown condo, and apparently a $5,000 wedding dress. And I understood, with a very specific kind of clarity, exactly how much of what I'd believed about my ex-husband's life had been subsidized fiction. The second professional I'd come to know in this process was a forensic accountant named Priya Nagesh, brought in by Renata's firm to formally trace the trust distributions and determine, with documentation solid enough to survive a challenge, exactly how much money had flowed to Mark's household, through what channels, and under what stated purposes. Priya's findings, delivered 3 weeks after the wedding in a report that ran to 19 pages with attached bank statements and wire confirmations, showed a pattern that even Carol hadn't fully anticipated. The advance on inheritance distributions had increased sharply in the 4 months leading up to the wedding, coinciding almost exactly with the period Brittany had been planning the ceremony. 2 separate wire transfers, one for $18,000 and one for $11,500, had been routed from the trust's disbursement account directly to a wedding venue holding company and a bridal boutique, respectively, meaning the trust hadn't just been subsidizing Mark and Brittany's lifestyle in the abstract. It had directly funded the specific wedding at which Brittany decided my daughter didn't belong. Priya's report also surfaced something Carol hadn't known. 3 months before the wedding, Brittany had contacted Renata's office directly, not through Mark, asking, in an email, Priya's document trail turned up through a records request, hypothetical questions about whether trust distributions to a married couple could later be affected by a divorce, and whether a prenuptial agreement could be structured to shield inheritance-linked funds from any future claims Mark's ex-wife or child might have. I read that email 3 times. Brittany hadn't been planning a wedding to Mark, exactly. She'd been planning access to a trust she didn't fully understand yet, with enough foresight to start asking about legal insulation before she'd even walk down the aisle. Lily wasn't collateral damage in an unrelated cruelty. Lily was, in Brittany's calculation, apparently a liability line item, a reminder of a prior claim on money Brittany intended to eventually treat as fully, uncomplicatedly hers. I want to be honest about the next several weeks, because this is where the story stopped being about a single terrible afternoon and became something more grinding and, frankly, more true to how these things actually unfold in real families. Slowly, through phone calls that go nowhere, through attempts at reasonable conversation that curdle, through a series of small failures before anything actually resolves. Mark called me 4 days after the wedding. Not to apologize, I want to be clear about that, because for a long time I kept waiting for an apology that never fully arrived, but to ask if I'd talked to my mother about not blowing this out of proportion. She said something unforgivable to our daughter, I told him, in front of 200 people, at your wedding. I know, he said, and to his credit, his voice actually cracked slightly on those 2 words, the first real emotion I'd heard from him since this started. I know, Dana, but Carol's talking about cutting us off completely, and Brittany's, she's not handling it well. I asked him, genuinely curious, how Brittany was handling the fact that she'd made an 8-year-old cry into a phone 30 minutes before her own wedding. Mark didn't answer that. He asked instead whether I thought there was a version of this where everyone calms down. I told him I thought there was absolutely a version where everyone calmed down, and that version involved Brittany apologizing to Lily directly, in terms an 8-year-old could understand, without qualification or excuse. Mark went quiet in a way that told me, before he even said it, that this wasn't a version Brittany was interested in inhabiting. He called back a week later to report, with the flat disappointment of a man delivering news he already knew would go over badly, that Brittany felt she shouldn't have to apologize for having boundaries on her own wedding day, and that she was willing to move forward if Carol would simply let this go. I did not relay that offer to Carol as a serious proposal. I relayed it to Renata, who added it, dated, and timestamped, to what she was now calling the documentation file, a phrase that, I'll admit, gave me a small, ugly satisfaction every time I heard it. Around this time, Brittany attempted a workaround I genuinely hadn't anticipated. She reached out to me directly, over text, for the first time in the entire 5 years I'd known of her existence. The message was long, warmly worded, and on close reading contained not one actual apology, only a series of sentences beginning with, I think there's been a misunderstanding, and I never meant for it to seem like. She asked if we could get coffee, just us, mom to mom, a phrase that made my stomach turn over, given the context in which she'd recently declared my daughter looked too much like me to belong at her wedding. I showed the text to Priya, mostly out of morbid curiosity about whether it had any documentary value. Priya pointed out dryly that the message never once named the specific thing Brittany had said to Lily. It apologized for a misunderstanding without acknowledging there'd been an actual, specific, quotable sentence. That's a pattern I see constantly in these disputes, Priya told me. People apologize for the fallout. Almost nobody apologizes for the sentence. I didn't respond to the coffee invitation. I forwarded it, unedited, to Renata's file. I want to introduce the third professional in this story now because her involvement surprised even me, and because it's the piece of this that turned what I'd assumed was strictly a family and money problem into something with actual legal teeth. 5 weeks after the wedding, Carol received a certified letter from an attorney representing Mark and Brittany, threatening to challenge the trust's discretionary withholding provision in probate court, on the theory that Carol's decision was arbitrary, retaliatory, and not supported by any documented pattern of harm, essentially arguing that one bad afternoon, however unpleasant, didn't meet the threshold Walter's trust language required. This is the point where Renata brought in Detective Marcus Felden, a financial crimes investigator with the county sheriff's office who had, over a 14-year career, specialized in cases involving elder financial exploitation and disputed estate manipulation, not because anyone suspected a crime yet, but because Renata wanted an independent, credentialed second opinion on the pattern Priya's forensic report had surfaced, specifically the timing of the 2 large wedding-related wire transfers relative to Brittany's email inquiries about prenuptial protections. Detective Felden's review, conducted informally since no charges were being contemplated at that stage, focused on one question. Did the pattern suggest Brittany had identified and begun maneuvering around the trust's protections before the wedding, supporting Carol's claim that this wasn't a single impulsive comment, but part of a broader approach to isolating Lily from family resources? His conclusion, delivered in a memo Renata later included as an exhibit, was blunt. The timeline showed a consistent, escalating pattern of conduct, not an isolated incident, citing the engagement dinner request that Lily not call me mommy, the pre-wedding legal inquiries about shielding funds from claims related to Mark's prior marriage, and the targeted nature of the comment made to Lily minutes before the ceremony. Isolated bad moments, his memo read, don't typically come pre-wrapped in prior legal research about how to protect the proceeds. That memo, combined with Priya's financial trail and Renata's legal framing, became Exhibit D in the eventual probate filing Mark and Brittany's attorney had threatened, except by the time it was formally filed, it was Carol's attorney filing it, preemptively, as a declaratory action asking the probate court to affirmatively validate her exercise of trustee discretion before Mark's side could challenge it. Renata's strategy, as she explained it to me over the phone one evening while I sat in my kitchen listening with my free hand pressed flat against the counter, was simple. Never let the other side pick the battlefield when you've already got better ground. I need to tell you about the Tuesday in late October when everything nearly fell apart, because up to that point I'd been a witness to this conflict, mostly furious, invested, occasionally consulted, but fundamentally on the outside of the actual legal machinery grinding forward. That Tuesday, I became a party to it in a way I hadn't anticipated, and for about 18 hours, I genuinely believed the whole thing might collapse in exactly the direction that would hurt Lily most. Mark's attorney filed a motion arguing that if the probate court was going to examine the totality of circumstances around Brittany's conduct, it should also examine my conduct as Lily's mother, specifically whether I had coached Lily's account of the flower girl incident, and whether my documented history of acrimony toward Brittany constituted an alternative, more plausible explanation for Lily's distress than anything Brittany had actually said. I remember reading that filing at 11:40 p.m. on my phone, sitting up in bed, my hands not quite steady enough to hold the screen level. It named me. It suggested, in careful legal language designed to imply, without technically asserting, that I might have manufactured or exaggerated my own daughter's trauma as a weapon in a custody-adjacent financial dispute I had, from Mark's side's perspective, every incentive to escalate. I called Renata the next morning before I'd even had coffee. She was calm in a way I found almost infuriating in the moment. And then, 20 minutes into the call, deeply reassuring. This is a pressure play, she told me. They know the financial evidence is bad for them, so they're trying to reframe the entire dispute as a credibility contest about you, because a credibility contest is the only terrain where they think they might have a chance. I had less than 48 hours before a scheduled hearing where the motion would be addressed, and Renata told me gently but directly that the single most most useful thing I could do was submit a sworn declaration, not about the wedding, but establishing an independent, documented account of exactly what I'd witnessed and when, cross-referenced against Carol's contemporaneous notes and the coordinator's own incident log from the venue, which Renata's office had already subpoenaed weeks earlier as a precaution. I spent that Tuesday night writing and rewriting a 4-page declaration, my hands genuinely shaking through most of it, not from fear exactly, but from the specific, cold adrenaline of realizing how close this had come to becoming about me instead of about what had actually happened to my daughter. I kept checking the coordinator's incident log, which Renata had forwarded me for cross-reference, a time-stamped internal note, logged at the venue 11 minutes after the incident, reading simply, guest conflict, flower girl removed from processional per bride's request, mother notified for pickup. 11 minutes, logged by a stranger with no stake in any of this before Carol had even walked down that aisle. It was, Renata told me the next morning, worth more than every adjective in your declaration combined, because it was untouched by anyone's motive. The hearing happened on a Thursday. I sat in the back of a courtroom I'd never expected to occupy, listening to Mark's attorney attempt, with visibly diminishing conviction, to argue that a subpoenaed, time-stamped venue log and a licensed detective's independent financial pattern memo were somehow less credible than a theory that I'd coached an 8-year-old's grief or leverage. The judge, a woman named Judge Patricia Osei, who handled the probate calendar with the specific, weary efficiency of someone who has heard every version of every family's worst behavior, denied the motion from the bench, describing the credibility attack theory as unsupported by anything in the record, and noting, with what I choose to remember as the faintest note of dryness, that the venue's own contemporaneous documentation does the plaintiff's theory no favors. I don't think I fully exhaled until I was back in my car in the courthouse parking garage. I want to be careful here, because I don't take pleasure in describing someone else's unraveling, even someone who earned it as thoroughly as Brittany did. But this story doesn't work if I skip the part where her composure actually gave out, because up to the hearing, she'd maintained a fairly consistent public performance. Wounded innocence, misunderstood bride, victim of an overbearing mother-in-law. That performance ended in the hearing itself, when Judge Osei denied the credibility motion and, in the same session, granted Carol's request for a formal evidentiary hearing on the trustee discretion question, meaning the actual underlying conduct would now be examined on the record, under oath, with Ria's financial report and Detective Felden's memo formally entered. Brittany, seated beside her own attorney, said something audible enough that 3 people later independently confirmed hearing it, including Renata. "This is insane. I said one thing." Her attorney visibly flinched. Judge Osei looked up from her notes for a long moment before simply moving to the next item on her calendar. Renata told me afterward that in 22 years of practice, she'd rarely watched a client's own words do more damage to their position in a single sentence, because the entire theory Mark's side had built depended on Brittany's comment being a minor remark blown out of proportion by a vindictive family. "One thing," said an open court with visible irritation rather than remorse, confirmed every piece of the pattern Priya and Detective Felden had already documented. It wasn't new evidence. It was Brittany, unprompted, agreeing with the prosecution's timeline. The formal evidentiary hearing was scheduled for 6 weeks later. It never actually happened, because 2 weeks before it was set to begin, Mark's attorney contacted Renata's office to propose a settlement. The terms, which Carol was under no legal obligation to accept, and which she genuinely deliberated over for several days before agreeing, were as follows. The discretionary suspension of trust distributions to Mark's household would remain in place permanently, not temporarily, formally amending the trust's disbursement schedule for the remainder of Carol's lifetime unless she chose, at her sole future discretion, to reverse it. Mark and Brittany would receive no further advance on inheritance payments of any kind. Any eventual remainder distribution to Mark upon Carol's death would be held in a separate subtrust with its own trustee, not Carol, and explicitly not Mark or Brittany, until Lily turned 25, structured specifically so that Lily's own inheritance rights as a named remainder beneficiary could never again be discretionarily entangled with the state of her father's marriage. Brittany did not attend the settlement conference. Mark did alone, and according to Renata said almost nothing throughout, signing where instructed, calculating exactly how much of his adult life had just been permanently restructured by 11 seconds of his wife's mouth moving faster than her judgment. I later learned, through channels I won't fully detail, that the settlement's financial terms placed real strain on Mark and Brittany's marriage almost immediately. The lifestyle they'd built together had been quietly scaffolded by trust distributions neither of them had planned to lose, and losing that scaffolding all at once has a way of surfacing every other tension a relationship has been avoiding. I don't know, as of this writing, whether that marriage survives its first year. I find I don't have much emotional investment left in the answer either way. I've spent most of this account on lawyers and trustees and financial pattern analysis, because that's genuinely how this resolved, through documentation and process rather than any single dramatic confrontation. But I don't want to end there, because none of it would have mattered if it hadn't. In the end, actually protected my daughter. Lily didn't attend a single hearing, wasn't named in any filing beyond the one motion Renata successfully had dismissed, and to this day has no idea that a trust, a forensic accountant, or a financial crimes detective were ever involved in what happened to her. As far as Lily knows, her grandmother gave a very dramatic wedding gift and then simply stopped inviting Brittany to Thanksgiving. That is, I've decided, close enough to the truth for an 8-year-old, and considerably kinder than the full version. What Lily does know is that her grandmother drove to our house 3 days after the wedding, sat with her on our porch steps, and told her, in words I've heard Carol repeat since, because she seems to need to say them almost as much as Lily needed to hear them, that she is loved exactly as she is, that looking like her mother is not a flaw to be managed, and that nobody gets to decide she doesn't belong somewhere she was invited. Lily asked, with the specific bluntness of an 8-year-old processing something too large for her yet, whether Brittany was in trouble. Carol told her that grown-ups sometimes have to have very boring, very long conversations with lawyers when they've said something unkind, and that this was one of those times. Lily seemed to find this both plausible and satisfying, and asked if she could have a snack. She still has the dress. It's hanging in her closet, 41 pearls intact, and she asked me a few weeks ago if she could wear it to her own birthday party in the spring, even though it's not a wedding, and I told her of course she could, because a dress that beautiful doesn't need an occasion that matches the one it was made for. It just needs someone who still wants to wear it. I think about that afternoon less often than I expected to, given how much of my fall it consumed. When I do think about it, I don't think first about Brittany's face at the mirror, or Mark's shoes, or even Carol's voice carrying to the back row. I think about Lily on the floor of that side room, asking a woman she barely knew why she didn't want her there anymore, and about the fact that within 15 minutes, without raising her voice once, a 68-year-old widow made certain that question would never again have a financial incentive attached to its answer. Carol didn't do it for spectacle, whatever it looked like from the back pews. She told me once, months later, over coffee at her kitchen table, that she'd simply reached the point where staying quiet cost more than speaking up, and that Walter, wherever he was, had apparently agreed with her 14 months before either of them knew exactly which afternoon would prove him right.